Namaskar and good afternoon to everybody. NCPCR has organized a Facebook Live webinar on forensic inputs in investigations of sexual offences, scope, challenges, and way forward as a part of activities on International Day for Elimination of Violence Against Women. On this occasion, we have with us distinguished guest Dr. G.K. Goswami, IPS, Chief of ATS, Uttar Pradesh, to speak on this important topic. Dr. G.K. Goswami, IPS, who in his various capacities in serving the nation was posted as Director of CBI Academy, Ghaziabad. He has also served as an expert on organized crimes in the United Nations Office on Drug and Crime, UNODC, and has had the fortune to share his experience and views on wide spectrum of issues related to policing and law enforcement. He has been decorated 3 times with Police Medal for Gallantry. He holds a postdoctoral degree in role in forensics in strengthening child rights under the POCSO Act 2012. He is an honorary professor of law at Rashtriya Raksha University, Gandhinagar, and is designated as Emeritus Source Faculty. Dr. Goswami has authored a popular book titled Assisted Reproduction and Conflicts in Rights, reflecting on equitable justice between reproductive rights of the parents and child rights to know genetic truth of one's origin. He has authored over 3 dozen articles published in academic journals of national and international repute. NCPCR is grateful to Dr. Goswami for speaking at today's Facebook Live webinar on forensic inputs in investigation of sexual offences, scope, challenges, and way forward. Over to you, Dr. Goswami.
Thank you, ma'am. It is always a great pleasure to get associated with National Commission for Protection of Child Rights. It's a very important commission for our country because through this institution, Government of India has enabled the children to get their rights in place. And in earlier interaction, I have found the professionalism and the commitment of every member, every official of this commission. They are highly dedicated and committed to the cause of child rights. With this background, I will try to talk about various aspects of investigation in sexual abuse. Of course, my focus would be on POCSO, but we must be aware that apart from POCSO, the act which came in operation on 14th November 2012, the Children's Day, prior to that, there was no specific distinction for dealing the sexual offense for minor or major. The very important aspect of POCSO is that it does not use the term rape. It talks about sexual assault, whether it is aggravated or non-aggravated. This is one thing one must learn. Apart from that, various aspects, procedural aspects, have also been explained separately. So it is a hybrid enactment. It has substantive provisions coupled with procedural provisions. So it is a hybrid act. There are several things to talk about, but the major, you can say, the challenge is that age determination. I will talk about age determination. In my presentation, I will give you some glimpse of scientific investigation, particularly the use of forensic science. And I will also share few observations of my own research for DSC, which I completed last year from National Forensic Science University under the guidance of Dr. J.M. Vyas, the Vice Chancellor of the university, who is a very known figure. Probably many of you must be aware about his credentials. In that research for DSC, I have examined more than 4,000 judgments delivered by various high courts and the Supreme Court of India ever since the POCSO Act came into existence. These judgments have given me to understand various strengths and challenges while dealing the POCSO Act. My dear friends, I have seen with my own experience in one of my case study in Bareilly that the child, the girl, was of 12-13 years at the time when she was abused. She got impregnated. Unfortunately, the detection of pregnancy was too late and she has to deliver a child. There is no iota of doubt that the girl was minor. She was 12 or 13 years old. But can you believe that as late as 2016, the POCSO Act was not invoked? And again, you will be surprised to know that even the matter has gone at that time for some, for termination of pregnancy, even up to the level of High Court. But I think even at that level, that POCSO has not been invoked, could not be acknowledged. So there are so many issues and challenges. Despite the law is there, the separate special enactment is there. But until unless we have the righteous spirit to implement the provisions, merely making law is not sufficient. There are so many other issues which I can talk with my own experience as a police officer, as an academician, and as a commoner. Everybody has so many, experience of this kind, not only in sexual abuse cases, but all through in the walk of life. So investigation remain very, very important part. The awareness among the stakeholders. We normally blame the police. Of course, I am not saying that police is always doing its job perfectly. There are so many defects, but other stakeholders don't think that they are above this problem. Be it a judge, be it an NGO, be it the prosecutors, and all sectors. So my request here is that until unless we induce professionalism by way of cultivating knowledge, by way of transferring experience, we may not be able to implement the intent of the parliament for which this special act, special enactment was brought in. So with this background, I would like to start my presentation. In the beginning itself, I would request that this presentation needs some more time, but I understand the dynamics and nuances of time. So I will skip few slides, but I will try to make you feel that after completion of this discussion, if you still have some doubt, I understand you will have a lot of doubts. So please come up with those observations, whatever you have. I will try to the best of my understanding to explain. If in case I am not able, I will try later on to find the solutions. But throw your questions, throw your queries, so that that deliberation may be fruitful. So I will be talking about the role of forensics in investigation of sexual offense. What are the challenges and how the way can be carved out. Before we enter to the discussion, let us understand why we are discussing this. What is the need? Why we have to give emphasis on scientific investigation? These are the statistics of 2014 to 2019. Very recently, 2020 figures have also been published. I will incorporate that, but our purpose will be solved. You see the two red brackets on screen at the left side. Police has filed charge sheet in rape cases, nearly 90% cases. Police feel that we have done our job, we have collected evidence, and we have filed charge sheet. Many times the accused have also been arrested. But when it is being tested, it is being examined during trial proceedings in the court, the conviction is nearly 30%. I am not saying that conviction should be 100% or whatever. My only take is that if a person is innocent, then why he should be languishing in the jail? Why the charge sheet has been filed? And if he is a culprit, he is an offender, then due to lack of evidence, cogent evidence, why he should be acquitted? Then what the girl who is a victim, what the family where the girl has suffered, what they will feel if a person get acquitted, if he is a culprit. So either way, whether he is an innocent or a culprit, it should be proved with cogent evidence. That's the purpose. So this gap of nearly 60% between charge sheet and conviction, the remaining part which get acquitted, that is the major concern for us, how to bridge this gap. If we see the POCSO, the situation remains almost similar. Here again, you will find that charge sheet filed in more than 90% cases, but conviction is about 30 to 35%. Again, the 60% problem. This is for POCSO what we are going to talk. And again, pendency, you just see, the POCSO had made provisions for special court, special prosecutor, everything done. But unfortunately, pendency is nearly 90%. Can we justify it? In my empirical study, I have asked this question to the judge, trial judge. At least I could not get satisfied by their answers. And believe me, there are hardly 5-7 witnesses to be examined in such cases. There may be an injury report, the medico-legal. There may be a victim or some family member, maybe 1 or 2 forensic experts. So how many people to be examined by the court? I think this pendency at the level of court is also a matter of concern. And this is pan-India problem. Can we justify this? Delayed denied justice is a very known axiom. Are we really serious about it? So that's the major issue one has to think about. Again, human trafficking, the issue remains same. Human trafficking, it may be child, it may be adult. And human trafficking is a bundle of crime. Mostly the females, they are being trafficked for sexual abuse, for forced marriage. They sometimes turns into flesh trade in different area of our own country, or maybe they may be transported out of the country, the human trafficking. So this is again serious issue. And if you see the charge sheet is in nearly 90% cases, but conviction is again 20-30% only. So this problem, not only in human trafficking or sexual offense, by and large, this problem remains same. So the point up to this level, what we have discussed is that the evidence collected by police are not sufficient to result in conviction. So how to bridge this gap? That is major concern for us to talk. So prior to go for detailed discussion further, let us understand how the sexual offense have been classified in our legal lexicon. POCSO after 2012 had been separated, which is being shown on the top of this slide. Otherwise, sexual offense has been classified into two segments. One is the harassment and another is assault. Harassment has two sections to deal with. One is 354, outraging modesty, and 509, outraging decency of a woman. Sexual assault, 375 define rape, and 376 award punishment, quantum of punishment. So this is the broad classification. This slide actually I constructed at the time when #MeToo was in operation. Not operation exactly. It was matter of talk at that point of time in 2018 or so. So there was talk that if you deal the old cases by criminal method, then you have to prove beyond reasonable doubt, because this is the basic requirement of the law. But in old cases, you cannot prove because there is no injury, there is no semen, no other forensic science evidence available. So there was one argument that can we think such cases to deal by civil disputes by way of preponderance of probability. So this is a thought actually. I don't want to get more into discussion, but it is a very interesting discussion although. Now, you remember Nirbhaya case. Everybody, I think those who are dealing with rape jurisprudence, they are aware of this case. On 16 December, in midnight almost, a girl later nicknamed as Nirbhaya, 22-year-old paramedic student. She was raped brutally in a moving bus and injured very badly in barbaric manner. The crime was highly diabolic. She succumbed to injuries. She was sent to Singapore for better treatment. After that, the government of India brought two amendments. The Criminal Amendment Act 2013, and there was a separate enactment, the Sexual Harassment at Workplace 2013. This second act is least talked. That is why I have shown it in smaller font compared to the upper one. The Sexual Harassment at Workplace is the derivative of Visakha case, where Justice Verma, the then Chief Justice in 1996, called out some guidelines and defined what is sexual harassment. So these are the two major legal remedy brought in by Government of India at that point of time in 2013, post Nirbhaya effect. Let us see what were the changes the Amendment Act 2013 set in our legislation of rape jurisprudence. Basically, if you look closely, you will find that lot of imprint of Sexual Offence Act 2013 of United Kingdom. we have borrowed many things. Broadly speaking, it has broadened the definition of rape beyond penovaginal penetration. Earlier, rape was confined to either attempt or commission of penetration of penis into vagina. Now it has brought any part of body or any object in any orifice of female or male. Now, in case of rape, it is female only. The orifice may be vagina, maybe anus, maybe nasal, maybe mouth, like that. So this has been done. Now, Parliament thinks we have done our job. Of course they did. But as a police officer, my question is whether we have enough tool, forensic tool or evidentiary tool to address the expansion of this definition. Can we collect evidence of this sort? Let us see what kind of evidence we collect in case of rape. If it is a case where matter is reported soon, maybe 5-6 days, even within 5-6 days, you may get bodily injury to be detected. So medico-legal report is one parameter. Another one is the forensic tests or forensic sampling, which include vaginal swab, anal swab, breast swab. Normally, what we look for, either semen or blood or saliva or hair. I mean to say any bodily material, biological material, which get exchanged from one body to another body. But, my dear friends, consider that if the allegation is that a person put tongue into vagina or put finger into vagina, do we have forensic tool to collect any material in those cases? So far, answer is no. There are so many such situations, meaning thereby that merely by expanding definition is not going to solve the purpose until and unless you have the corresponding tool for evidence collection. This is the catch point, and that's the problem until unless you provide sufficient tool. So this is the area where research and development needs to be promoted. That's the major issue. Now, let us talk about what is investigation of rape cases and what are the challenges. My dear friends, fairness is the quintessence of justice. Until unless you express fairness, you express transparency in your act, even at your normal deeds at home or in office or wherever you are. If you do hanky-panky, if you are biased, then nobody will believe you, nobody will be happy. People will agitate. People will go to court. Your decisions will be challenged in one way or other. So fairness in our activities, whether it is investigation, whether it is trial, whether it is other aspect of criminal justice system, the focal point is fairness. One thing I would like to add here itself, that in our judicial process, in our human right domain, we have given a lot of emphasis to fair trial. But can you believe, can you really say that if investigation is not fair, merely fair trial is sufficient? My limited observation is no. I can firmly believe, with my 25 years of experience in police now, that until and unless you ensure fairness in evidence collection through investigation, fair trial is a farce phenomena, farce legal construct. It's a utopian concept which can only exist in papers. And this is happening day in and day out in our day-to-day affairs. So if you really want fair trial, you first go, because investigation is the bedrock for trial. It is the initiation of trial. If there is no investigation, what a judge can do? If judge do not have the proper evidence, how can he deliver justice? How can he find truth? So this is a problem. It is a fundamental problem. It is a global problem. Now, another issue, delay in FIR. Suppose if a case happen, say for example rape, if it is inordinate delay, then there will be a kind of suspicion until unless you explain it reasonably. There may be some distance. There may be some situations where there may be threat. If you go out, if you go to police station, we will kill you. That type of scenario may be there. So if you have reasonable explanation for delay in FIR, that is very important. If you do not have, then the person will ask, the system will ask you, why have you not come in time? Why were you sleeping on your rights? That's important. Another is consent. You see, my dear friends, sexual activity actually is involved in rape. Rape is a sexual activity. Sexual activity is a normal phenomena also, because it is a human behavior. It is very important for perpetuity of the society. If you do not have the sexual activity, the generation cannot be begotten. So sexual activity is a biological need. It is a social need. So how a biological, how this activity can be defined, whether it is consensual, whether it is a rape or it is normal activity. It is the consent actually. So consent is the thin line dividing this as a crime, and if it is a genuine consent, then it will be a normal activity. So consent is a very, very important point. At this moment itself, I must say that law believe that until and unless a person is of 18 years, then consent, whether given or not, has no meaning. That means it will be considered rape only. And it is called statutory rape. This word statutory rape means that consent is meaningless. And statutory rape is confined to minors only. So for POCSO, rape activity or sexual activity is considered statutory sexual offense. Then sole testimony. Sole testimony is important, my dear friends, because in rape cases or in sexual offense, most of the time, you won't get any eyewitness. So testimony of the victim is very important. It becomes sole testimony doctrine. We'll talk about this. As I said that there won't be any eyewitness. So we have to corroborate the circumstances. So corroboration is again very, very important tool, not only in rape cases, but in general administration. So one should understand what are the nuances of corroboration. We'll talk about this to some extent, and how the role of forensics can, bring better and transparent system of evidence collection. So we'll talk about the role of forensics in the entire gambit of evidence collection in a more scientific manner. So this is the broad spectrum we are planning to talk about. As I mentioned, sole testimony. Sole testimony is basically depending on the statement given by the victim. It may be in other cases also sole testimony, but normally it is more relevant for sexual abuse. Justice Vivian Bose has given his opinion in Rameswar versus State of Rajasthan. It is a very important judgment to understand. Those who have interest may see it, look at it. The observation of Honorable Supreme Court in Hijri Bai case of Gujarat is very interesting to understand. The judges says, corroboration is not the sine qua non for a conviction in rape. Why? The reason is, in Indian setting, refusal to act on the testimony of victim of sexual assault in absence of corroboration as a rule, if we made it, will add insult to the injury of the victim. Why should the evidence of a girl or the woman who complain of rape or sexual molestation be viewed with the aid of a spectacle fitted with lens tinged with doubt? So this is very important. You shall see, crime cannot be seen identical in every society. You have to take social context in consideration. So in Indian setup, we have to think on those lines which Honorable Court has mentioned, although you may differ to this opinion, but by and large, this is the viewpoint of Honorable Apex Court of India. You can see this Vijay versus Chini. This is also a very important case. My request to you, those who have real interest in this subject or in any legal subject, please read out law through judgments. Judgments are basically live commentary. Both sides speaks and judge as a neutral umpire, as a adversarial master. He or she, a judge, explain and review the argument given by both sides of defense as well as prosecution. And then, based on the logical argumentation, the judgment is being passed. So, please make habit of reading judgments. That will give you better understanding of law. And with my own experience in LLB, LLM and subsequent study, my strength, I always find, was reading judgments, and that is quite interesting and live law. These are the defense plea for POCSO. How defense will cut you short in the court. If we understand how our defense will attack us on the prosecution, we can strengthen our armory. So as I mentioned already, that in case if there is inordinate delay in reporting and we do not have any plausible explanation, then they will hammer this point. So in case there is any inordinate delay, please find out some logical reasoning behind it. Why? Then majority of age. If child is of 5-6 years, then no problem. But if a child or minor is of age of 16, 17, close to 18, I mean to say, then they will contest this and they will try to prove that prosecutrix is of age of above 18. And once they prove this above 18, then POCSO will remove. And then second choice will be, they will say that it was consensual. It was not by force. So this is step by step. In case there is no injury on body, especially on private part, then their assertion that it was consensual will get fortified. So most of the time, if we do not collect proper evidence for corroboration, then defense will demolish our case. So these are few suggestions actually to my dear friends, that please, as police officer, as investigator, as prosecutor, please look at it. Strengthen these evidence if the case is real, and then you will get better results. This is age determination. In fact, if you see the scheme of POCSO Act, then you will find that section 34 of POCSO Act talk about power of court for age determination. It is the court who will decide. But how to decide? What is the procedure is nowhere written. That's the challenge actually. Unfortunately, they did not give any procedure to conduct age determination by the court. This issue was raised just after POCSO came into being in Jarnail Singh case in 2013. Then court gave the solution that look, POCSO does not have the standard formula for age determination. That is right, but court has been enabled to do that. But procedure will be followed as per JJ Act, because JJ Act, Juvenile Justice Act, it has elaborate mechanism. So earlier, Rule 2007, Rule 12 of 2007 was the thumb rule, but now you must be aware that JJ Act has been repealed and new Act of 2015 has been brought in. This is not 2005, it is 2015 actually. I will correct it. It is wrongly written. It's section 34. Sorry, it's section 94 of the new act has given elaborate mechanism which is written down. It means that you have to look first the matriculation certificate. First is the matriculation certificate if the child has done matriculation. If of course it is not done in maybe the younger age or maybe not up to that education, then second, date of birth from school, if the child has gone to school in any way. In case not, then birth certificate by corporation or municipal corporation. If all three are not available, then only you go for medical opinion. Many times you will find that for certain regions better known to the IO, they jump to go for medical opinion. My dear friends, there is no medical examination which can determine age perfectly. There is minimum plus minus 2 years. Suppose the girl is of 16 years, if the medical examination says, then it may be 14 or 18, and always better of the benefit of doubt is given to the accused. So the court has to consider it for 18. So, and completely the case will turn around. So age determination by medical means is not the solution in such cases, and we do not have better option. So this is yet another challenge. I think there is again very dire need for research and development. Section 35 of the Evidence Act, entry of DOB, date of birth, in the school register is admissible under this section of Evidence Act. But here again catch point, and most of the time in POCSO cases, this is the major problem. This section says that the person who has furnished the information will explain it, that on what basis have you done. Say, so, for example, in remote area where the parents are illiterate or semi-illiterate, not much aware, and they have written X date of birth of the child, then the defense lawyer will ask how you came to know, because there is no medical certificate, hospital certificate, because the children are born most of the time at home. So there is no certification in the hospitals. So they will say that how can you say that the child was born on this particular time? And being their illiteracy, being their ignorance, they are not able to respond and benefit of doubt will go again to the accused. So this is yet another area, gray area, where defense take advantage of ignorance of the parents. And this, if you want to read further, in 2019, Sikkim High Court has beautifully written this entire gambit of this legal problem in Girjaman Rai alias Kamini. So this judgment is worth reading, those who have some interest. These are some significant judgments on rape. Again, the time is running, so I will not read, but all the judgments which have been written are very, very significant. These are all Nirbhaya case, Anokhi Lal, all cases. I should have given some 2 minutes time, but I understand the limitation of time. Likewise, these are very important judgments for child sexual abuse. At least these 4 judgments who are anyway connected to deal with sexual abuse of children must read these 4 judgments. That is my humble request. Now, investigation. Dear friends, for investigation, what is the major, what is the centric point of investigation? Criminal investigation, rather. In most of the time, particularly for body offense, and not only for body offense, even for property offense per se, even for cyber offense, it is the human being to whom we are looking for. How? We are always looking for an individual who has committed crime. Even if named is FIR, exists in the FIR, it is named accused. Even then we have to prove his identity beyond doubt, that he is the person who committed the crime. On other side, the victim. Maybe the victim is not known. Victim is missing. The identity is not available by face. Face may be putrefied, the body may be putrefied. You may get only bones. So there are so many challenges. So human identification is the core of criminal investigation. We have so many methodology, morphological feature. I am G.K. Goswami because my face says so. My photograph also connect my identity. Videography also. Fingerprint is one another tool, very important tool, vital tool. Serology, my blood group, although blood group, entire society, entire human race is divided into 4 blood groups, but it gives some kind of, connectivity with identification. Voice sample, again, very important tool. And Ritesh Sinha in 2019 is a very celebrated case where Supreme Court has empowered the court to take the voice sample for matching. The DNA profiling, the ultimate gold standard for human identification. So these are the tools actually. But my take is that it is not only the forensic science or the procedures that are important. Important is your scientific temper into your mind. And that can be explained or portrayed by one very well-known example of King Solomon. In his court one day, 2 females entered, quarreling with each other, claiming the motherhood of a child, a small child, which cannot speak. They were quarreling, saying that at that time neither DNA nor fingerprint, nothing was available, probably. But his mind was sharp. He was a man of scientific temper, as a judge, as a king. He ordered to bring a sword, and he said that I will cut the child into 2 pieces to divide among both ladies, between 2 ladies. One of them cried, saying that, no, please don't do that. Hand over the child alive to other lady. And he identified the crying lady as mother. So here there is no photography, no DNA. It is only the mindset. My dear friends, it is the mindset actually which give you 6th sense. And sixth sense in investigation is very, very important. You should always be suspicious. And suspicion is the right of the police for investigation. And removing that suspicion is the right of the judge. So core subject is suspicion. One side police, another side judge. So that's very, very important phenomena to happen as far as justice is concerned. This is the investigation. Basically, investigation is what? It is pursuit of truth. Every stakeholder, every actor of criminal justice system is basically serving the purpose of finding truth to help the court. I have already told about the fairness. This right side down is written Innocence Project. Innocence Project is basically carried out in 1996. Rather, it started in 1992 after DNA was invented to help those convicts whose appeal were finally decided, awarding them conviction. But they were knowing well that they have not committed this crime. So they asked to conduct DNA on those cases. And you will surprise that till date, till 2020, in US itself, more than 165 odd number of convicts were found innocent. And many of them were on death row. So believe that country like US, where system is far better than us, if they can commit wrong for various reasons, they can convict the innocent people finally. You can believe what the grim scenario in Indian climate. So this is the strength of this project. This is corroboration is very important part. And for corroboration, these are the judgments. Actually, you can just read Sharad Birdichan, the Punch Seal, 5 guidelines they have given. And this is the latest judgment in 2009, where 5 guidelines have been clubbed into 3 groups. So you just read out whenever you get time, because for investigation, knowing about the circumstantial evidence or corroborative evidence, these are called circumstantial evidence or corroborative evidence. Because circumstantial evidence actually fill the gap in the chain of events. That's very, very important. Until unless you you complete the chain of event, you cannot reach to a logical conclusion. And corroborative evidence are those legal tools by which those missing chains are being linked. So this judgment is very important of the Supreme Court judgment. Now let me enter into corroboration. And forensic tool, they are very important for purpose of corroboration. So what is forensic science? Forensic science is basically, it is baseline for scientific investigation. It enhances probability of evidence, and the entire purpose of this whole exercise is marching towards perfect justice. So perfection is justice, spotless justice, flawless justice is the ultimate aim, so that no person can feel. If justice is correct, then people will have faith in governance. Whatever good development you do, if people do not have the faith in our criminal justice system, the system will collapse. This is the point. How we can induce faith among commoners. They should believe. In my own experience, I have seen people losing their parents, people losing their near and dears. But at that moment also, they say that, please give us justice. So in any damn situation, bad situation, still people cry to get justice. So justice is ultimate in life. These are some development how forensic science was developed. I don't want to get into that. I will just rush into this slide and then I will go for DNA. This is basically Article 20 part. These are, our Indian Constitution is very important. It is the mother for all laws. But for our criminal investigation, Article 20 is very, very important. It has 3 parts. And part 3, although 1 and 2 are equally important, I'm not saying, but part 3 is very important for forensic purpose. Part 3 says that you can not compel anybody to speak against himself. You see, if you really want to get away with third degree everybody knows, I hope. Third degree means use of violence by law enforcement agency. LEA means law enforcement agencies. Here we are talking about the investigating agencies or IO, investigating officer. If there is hardly any chance that an investigator, why they use third degree? They do not have any personal animosity. Why they do that? Why they took law in the hand? Their purpose is merely to get information about how the crime had happened, what was his role. And in doing that, for that purpose, they abuse the power and they beat a person. They use third degree. How can we get away with this? That's the challenge actually for entire globe. It is not only India. You must have heard a lot of instances across the globe. People hitting the head and many such bad instances. So let us understand what the degree business. Dear friends, if there is third degree, there must be some first and second degree also. What is first degree? What is second degree? Third degree we have understood. So first, second and third, these are numerical values. And degree is something we are quantifying. We are quantifying here basically torture. Torture, my dear friends, may be either mental or your bodily or physical, you can say. Physical torture or bodily torture, it is completely proscribed. You are not allowed by any law, in entire world. So third degree is completely wiped out. Now you left with first and second for interrogation. First degree means when you call somebody, you ask general questions. Who are you? How much you know about this crime and all. Up to this level, person is under mental stress, but it is only first degree. The moment you start confrontation, cross-examination by police, I am not talking cross-examination in the court. I am talking cross-examination means what the subject, what the accused or suspect has said. You are countering that, confronting that. So confrontation is ultimate aim of investigation. And how you can do that? You can do if you are aware of the background, the facts of the entire case. You may not be knowing entire facts, but whatever facts you have to confront with that fellow. Say for example, it is a murder case. You asked him that it happened in Delhi on X date. And the suspect or the accused, he says that I was not there. I was in some X city, other city. I was knowing this girl who was killed, but I have no business of this crime. But if you prove in counter examination or confrontation that look, you are saying that you were not in the city, but your CCTV footage where you were traveling in this particular car on that fateful day, that girl was captured in CCTV footage on any roadside or somewhere with you. So these are some examples by which you can confront. But for that, you have to prepare proper questionnaire. You have to do lot of exercise. Rather than doing that exercise, people used to go from first degree to third degree. So the actual investigation, my dear friends, lies in second degree. So promote that. If you promote that, you can successfully wipe out third degree. These are another case law, Kathi Kallu about the fingerprint. Nandini Satpathy talks about right to silence. Selby talk about the deception detection technique like narcoanalysis and others. Ritesh Sinha I have already mentioned about voice spectroscopy. All these judgments are very important, must have been discussed, but I know the time. Right to privacy, very important, but I am skipping it. All these things, these slides I am just passing through. Now let me just talk about the some sections so that you must understand. Basically, as I already mentioned, that we have procedural law, the Evidence Act. Evidence Act is equally used for criminal matters as well as civil matters. However, CRPC exclusively used for crime or criminal court and CPC for civil matters. So here this section 45 deals with expert opinion in the Evidence Act. And from 45 to 51, basically all these sections are important. You just have look as and when you get time. I will just skip. 293 of CRPC, 292, 293 and 294. These three sections are equally important there. Now, this is Locard exchange principle. Locard exchange principle says it is exchange basically of material. When two bodies or two items, two articles, they come close, then they exchange some material. And this is the basic principle for forensic science. So when two bodies, say for example in rape cases, two bodies come closer. So they exchange either semen, blood, saliva, hairs, and nail clips and all, so skins and many other things, right? So Locard principle is very important to understand how you can get forensic evidence or forensic samples for further investigation, right? These are some probable scientific evidence to be collected. Chain of custody is very important because it protects the integrity, the virginity of the sample. Otherwise, it can be manipulated. And if the defense break the chain of custody, it is a procedure actually. Those who have interest, I have also written extensively on chain of custody in few of my articles. They are available on ResearchGate. Those who have some interest can write my name on Google. You will get ResearchGate, and if you click so many articles I have placed there, they can be downloaded free of cost. So now quickly I will rush to DNA because DNA is very important forensic tool. So before I begin, I will just tell you few more things. DNA means deoxyribonucleic acid. It is being found in every cell, and in cell are the building blocks of the body, whether it is plant or animal, right? But we are talking about animals, particularly human being here. And the double helical structure of that was actually rotating on the previous slide. It is called double helical structure, and it was invented by Watson and Crick, the two great scientists who were being awarded the Nobel Prize. And based on this research, the DNA science has given birth to biology, biotechnology, and it becomes wonder science. I think in every walk of life, whether it is space science, whether it is medicine, whether it is criminology, whether it is ecology, so many things. I think now you tell the science, everywhere you will find some imprint of DNA. So this becomes science of wonders. This is the double helical structure in more specific manner, ATGC and all. This slide is important to talk about. This gentleman, he was a research scholar in Lancaster University since 1970s. He was working on DNA for identification of human being, but he has no business with crime. In 1984, specifically on 10th September, in 1984, I'm talking, he found, and he called that movement Eureka. He was running basically the jail of 2-3 persons. Basically, he took sample, the two children and the father who was serving as laboratory technician in his lab at that time. And they were trying to say that, is there any connection between parents with the child? So that was the Eureka moment when they run the gel. That is called chromatography. Now that is very old technique. Now they have different things. I will talk something later. So they could identify the human beings by way of DNA. And they gave the name DNA fingerprint, because fingerprint was used for human identification and DNA was tagged with fingerprinting, so that DNA is now will be used like fingerprint for individual identity. This was in 1984. Till date, DNA fingerprint has no connectivity with crime. Now comes 1985. Here, this was the first entry of DNA into courtroom. No, exactly not in courtroom, but for some dispute resolution. It was not in courtroom. I tell how. Basically, there was one dispute. A Ghanaian lady was staying with 2 children in UK, and third child was brought in. The government thought that this child, which has come just, is on forged documents. The mother is not same. That means the mother is forged so that he can enter into Britain. So that was the dispute. By the time, the DNA fingerprinting was very much publicized. So the defense lawyer or the lawyer of the mother, he requested the authorities, the immigration authority, that please conduct DNA. And when the DNA was conducted by Alex Jeffrey, it proved that child belongs to the mother. And based on that, that result was accepted by the authorities and case was closed. So this was the first episode where DNA was accepted for civil dispute resolution. It was basically a civil matter, not a criminal matter. Now comes 1986. 84, DNA fingerprinting was invented. 85, its first role came into dispute resolution. 86. What happened in 86? In 1983 earlier, a girl of about 15-year-old, she was brutally killed after rape. In the same manner, in 1986 also, with the same age, almost at the same place, having thrown out of stone thrown distance, maybe 30-40 meters, with the identical modus operandi, the girl was raped and killed. Both were cold cases. Police caught Richard Buckland, who was at that time 17-year-old boy, having a speech problem. But somehow he accepted to commit the second rape and murder. There was some doubt on the acceptance of guilt. So he was first, his DNA was taken, his blood sample was taken by Alex Jeffrey. This was the first attempt for crime. And it proved that he is not the culprit. So Alex Jeffrey first proved the innocence of Richard Buckland. This is first observation. The second observation of this case was that the accused in both the cases are same. That means the same person who is not Richard Buckland, he is somebody else, unknown person so far. He is the culprit for commission of both crime. So these are the very two important observation by Alex Jeffrey in this case. Then, interesting. Now then, who committed? They consider that should we collect blood sample for all people living there in that vicinity. When you do that, that is called DNA dragnet. When you collect blood sample of a specified area. It was a huge investment because more than 5,000 people were living, more 5,500 plus people were being investigated, you know. Then who will give the fund? Then the then Prime Minister Margaret Thatcher was approached. You see the greatness of these countries. By the time it was not sure that this technique will be helpful, but they sanctioned huge amounts so that the DNA sample can be collected and it will be tested by the laboratory. It was huge investment. Even till date, when it has been subsidized a lot, the cost has been reduced. Still we cry that we do not have money. But you just see that they could invent because that is why they are always ahead of the time. And when this sample was collected, one very important thing happened. One person was sitting in a pub. He was serving rather. He disclosed that I have submitted blood sample on behalf of my friend. This was overheard by somebody and they called this fellow and it was disclosed that it was Peter Pitchfork, again a boy of about 21-year-old at that time, that he had asked him to give sample. Then Pitchfork was called, his sample was collected, and rest is the story. It was matched. So he was the real culprit. And interestingly, he was given at that time 30 years of punishment. Later it was reduced to 28. And on 10th of September this year only, he has been released after completion of his punishment. So that is how DNA came into picture, both for proving innocence as well as establishing guilt. So this is the beauty of DNA. Without taking much of time, because I know I will not touch any point of now onwards, I will just rush to one of my observations. Yeah, these are the 2-3 slides only. I will take only 2 minutes now. You see, these are the results of my DSC research. I have proved here, earlier we have seen in our beginning, in the beginning of our talk, that in POCSO cases we have conviction about 30 to 35%. Okay, that was the question we have raised, how to build and how to mitigate this problem. My research says that if we conduct DNA, if it is found positive, if we conduct medico-legal, if it is positive, if 164 is also being recorded, 164A statement of the female, the victim, if these are positive, you will get 100% conviction, 100%. Now, in most of the cases, we conduct medico-legal, and in children cases, the reporting is very quick. So you just simply get injuries on the private part if it is rape. 164 is also mandatory. So these two things are always being carried out. Only thing is DNA. Can't we do DNA in every case? This is the challenge actually. And there is no challenge per se. This is mental challenge. Nobody force. And I tell you that until unless law is made that DNA should be made mandatory, of course, there may be some exception. I'm not saying if there is some technical problem or something, then it can be some exception. But as a rule, DNA should be done. We have 53A section, 164 section. Only thing, and I request the authorities sitting here, because it is the apex body in the country, consider that how can be recommended that DNA should be made compulsory in all POCSO related cases, particularly the penetrative sexual assaults. So this is no, this slide again establishes that if you have conducted DNA, then the time for trial will also reduce to half, nearly half. So DNA not only help in general conviction, but it also expedite the trial proceedings. So I think with this now I will just close this session, and I don't want to take much of time because already I think I have almost close to 1 hour and 10 minutes. So if there is any question, please ask. I can respond to the questions. These are my mobile number and mail ID. Those who are interested can contact me further. Yes.
Namaskar. It is my privilege to thank Dr. G.K. Goswami, IPS, who spoke extensively on the topic Forensic Inputs in Investigation of Sexual Offences, Scope, Challenges and Way Forward. NCPCR is especially grateful to you, sir, for your insights into the subject and being with us at such a short notice. I, on behalf of Chairperson NCPCR, Shri Priyank Kanungoji, thank you once again for taking out time from your busy schedule and being with us and sharing your knowledge. Thank you, sir. I also thank the viewers for being with us throughout this webinar. Thank you all once again. Namaskar.
Thank you. Thank you very much. Thanks for patience listening.